Recently, around 5 foreigners were asked to leave India by Ministry of Home Affairs. This was in the context of anti-CA protests. Let's have a look at the pros and the legality of this move. The first and the most important provision here is MHA's visa guidelines, which states that foreigners have to adhere to the purpose of the visit. Using this, MHA said that these foreigners were getting indulged in anti-government activities. However, what constitutes anti-government activities is not defined in these visa norms. However, the court might interpret and the government might argue that anti-government activities for foreigners is the same as anti-government activities for the citizens. This provides a legal ground for the use of Section 124A of IPC, which amounts to sedition. The third provision is that everybody and anybody has to follow the law of the land, and this has an impact on sovereignty of India. The fourth provision is the fundamental right of Article 19(1)(b), which is the right to assemble peacefully and without arms, essentially the right to protest, is not available to foreigners. Let's have a look at the cons of this move. Article 21A, which is a right to life and personal liberty, is available to foreigners. Second provision is, in some of the cases, the government has taken the action without specifying the reason. This is clearly against the principle of natural justice, which states that every person has a right to be heard before the punishment. The second problem is Delhi High Court judgment of 2019, which said the government does not have unfettered power and thus must provide a reason. The third problem is that India has been losing its rank in the World Freedom Indices. Fourth problem is the impact on the tourism industry. According to the World Travel and Tourism Council, it constitutes 6.8% of GDP, 8% of employment, and 30 billion US dollars of forex reserves.